THC and driving and the impairment parameters, should we say? Would you mind unpicking some of that for people?
Right. Okay. A lot
of
people assume that cannabis is like alcohol and is like it's pretty much a straight line between the amount of amount you've had and how impaired you are, and it's not like that at all. In fact, a lot of studies have found very, very limited, if any, impairment from using cannabis, and it tends to be relatively short-lived, maybe 2-3 hours or so after use. But what you tend to find is that with alcohol, people tend to lose their inhibitions, tend to drive fast and be reckless, whereas with cannabis, people tend to be more overcautious. So that you're more likely to run into the back of a car than to run head first into somebody else. And they tend to sort of drive at or below the speed limit, which is rather than being excessive, and compensate for the impairment by improved behaviour. So what we found was that young men who use cannabis were less likely to have accidents than their sort of alcohol-using peers, whereas young women were sort of more likely to have accidents. And we put that down to the fact that women tend to have better driving behaviour to start with, so that any sort of impairment tends to overwhelm that. Whereas with cannabis, with young men, their driving behaviour tends to be pretty poor to start with, and the improvements in the behaviour more than outweighed the sort of impairments in performance. So that it's not somebody that's been driving under the influence of cannabis is not necessarily a danger to others. So what you tend to find is that young drivers and people inexperienced cannabis use and inexperienced drivers are more susceptible, because if you actually have to think about changing gear and exactly where to sort of position yourself in the lane, so it's actually conscious, you have to think about it consciously, that's more susceptible to disruption than when things are pretty much done on autopilot. So that if you've been driving for several years, then you're much less likely to be impaired than if you've only been driving for a few months. But of course, it's the ones that have been driving for a few months that are more likely to have the accidents in the first place. So what we found was, back in the day, the police had to prove two things: had to prove that you're intoxicated or under the influence of drugs, and you have to prove that you're impaired. And so you had things called the field impairment test, where you'd have to sort of stand on one leg, holding your nose, counting to 30, touch your fingers to your nose from both sides, one-legged, standing on one leg, check your eyeball, how far your pupils dilated or constricted, which again was a bit of a red herring, because cannabis doesn't affect the dimension of the pupil, but it affects the colour of the whites of your eyes. It tends to make them look bloodshot. And what was the other one? Finger to nose test, the one-legged stand, the walk and turn test, so walk heel to toe and then turn around, etc. And part of it was assessing how well people comply with instructions, and part of it was seeing how impaired you are. But of course, I would have never stood a chance. I've got a really dodgy knee. I couldn't stand on one leg for 5 seconds without falling over, because nothing to do with cannabis, but because I've got a bad knee and my balance is shot. So that it's it was a fairly crude thing, but at least it was something to have an objective measure of impairment, rather than just saying that, no, you've got this amount in your bloodstream, therefore you're impaired, and therefore you've broken the law. So that when about 7 or 8 years ago, they brought in what they call Section 5A of the Road Traffic Act, they instituted what they call effective legal limits for cannabis. And in the case of THC, it is 2 nanograms per milliliter of blood, which is a very low level. And it's Theresa May, that introduced it when she was Home Secretary, was overtly saying this is about zero tolerance. So basically, if somebody uses cannabis, we don't want them on the roads. That's not to put too fine a point on it. That's what they are doing. Whereas in some of the sort of US states that have legalized recreational use, the levels 5 nanograms or 10 nanograms per milliliter. It's 2 here, and it's and so that you're very likely, if you've used cannabis recently, chances are you will sort of fall foul of it. And the other thing is that under the old system, they had to prove that you were impaired before they could take a blood sample. And by the time they got around to it, it was 3, 4, sometimes 5 hours had elapsed since somebody had been stopped. So that by then, their sort of cannabis, because the THC levels drop, the half-life in blood is something less than an hour. So that, you know, after 4 or 5 hours, the level is a fraction of what it was at the first. Whereas these days, now they just simply looking for, you know, the blood level, you sometimes find that the blood sample's been taken within the hour, so that somebody that would have got away with it, you know, a few years ago wouldn't do so now, because their level, they've been had it taken so soon. And it's just a flat level. They don't take account of how long it is since you've been there, since it was taken in the first place. So that you know, people are much more likely to fall foul of the law now than they were before. And obviously, the more toys the police have to play with, the more likely they are to play with them. So that they will, you know, treat the more likely to get a random stop. You're more likely to have a roadside test, which is a saliva test or a sweat test these days, and then if that's positive, then you go in and have a blood test at the police station. And I say it's very difficult to argue with, and although, you know, we do argue with it, and so, you know, as I say, the advice to anybody that is being stopped for this is, you know, insist on seeing your solicitor of choice before you have the sample taken. And, you know, although, you know, if you refuse, you can be prosecuted for refusing. You know, you simply try and delay it as long as you possibly can, because, you know, obviously, if you are, you know, well banged to rights, and then you deserve to be prosecuted if you're impaired, if you hit somebody, etc. Then you've really not got a leg to stand on. But if you've not, you know, if you've not actually caused a danger to anybody, or if you've not actually, you know, committed another traffic offence in the process, then it's rather unfair to have your licence taken away and all the other things that flow from that as a result of it. Because I say the other problem, of course, is that the level is so low that you can still be prosecuted for passive exposure. If you're in a car with somebody that's smoking a spliff, chances are that you're going to go over the limit, because it's a narrow, confined space. You're breathing their smoke in, and you can well end up being over the limit without being remotely intoxicated. So that it's the level is so low, it doesn't relate to intoxication. It doesn't relate to impairment. And, you know, it would be much better to have a higher limit and a sort of time limit on, you know, on a dynamic limit on how long it's been since you've been stopped and since the actual relevant time, and have a sliding scale as to, you know, whether somebody is you know, treated as impaired or not.